Hello and welcome back to Fraud in America. I'm Jackie Damar, your host. Today I have Sophie Luskin. She is a senior tech policy analyst at Cohen and Colapinto in Washington, D.C. And I have Claire Sylvia. She is a partner at Phillips and Cohen in San Francisco. And she literally wrote the book that professors use to teach the False Claims Act. So she's pretty qualified. I'm just going to turn it over to Sophie first to give a little bit more about your background.
Hi there. My name is Sophie. Alongside doing tech policy at Kohn and Colapinto, am a researcher at Princeton Center for Information Technology Policy. I study regulation issues and impacts around generative AI for companionship, social and peer media platforms, age assurance, consumer privacy, all to protect users and promote responsible deployment. And I'm very excited to discuss whistleblowing with the AI industry today with you.
Thank you. Claire?
Thank you. I'm really happy to be here to discuss AI and whistleblower protections with Sophie and with Jackie. I don't have a background in technology, but I do have a long background in whistleblower laws, and AI is certainly going to affect the way that those are enforced and how and the kinds of cases that we'll be seeing. So I'm looking forward to discussing that with everyone.
All right. Thanks for joining us in our second of three of these cool AI and whistleblowing podcasts. So thanks again for being here. All right, let's turn it over maybe to Sophie first. Can you talk about, as far as regulation of this industry goes, can you talk about some of the regulations that the states are implementing here? And I know there was a push for kind of a federal law, federal regulations around this that was not implemented in the recent budget bill. But states have started to regulate this in a couple different ways.
Over the past year in particular, state lawmakers have moved away from broader frameworks as it seems like they understand that this is not an issue that you can address in a one punch kind of method. It takes a lot of specific knowledge for the particular use cases that you want to address and prevent. So there's been a lot of legislation focusing more narrowly on transparency-based approaches to issues like chatbots, frontier and foundation models, content labeling, deepfakes, algorithmic discrimination, child safety, and government use of AI, for example. And the Future of Privacy Forum recently put out a report called The State of State AI that delved into the legislative approaches that have kind of emerged in the past year. So they found that there are three main approaches to regulating private sector AI right now. One is use and context specific regulations that target specific and sensitive applications. Another is technology specific regulations. And then the third is liability and accountability approaches that utilize, clarify, and modify existing liability regimes. So there's a couple examples within each of these categories. So for use and context-specific regulations for sensitive applications, that's focusing on certain uses of AI in high-risk decision-making contexts, such as healthcare, employment, and finance, as well as broader proposals that address AI systems. These bills typically focus on applications where AI may significantly impact an individual's rights, access to services, or economic opportunities. So a couple examples of that is Illinois had the HB 1806, which was on AI and mental health, and Montana's SB 212, which is AI and critical infrastructure. As for technology-specific regulations, that is focusing on specific types of AI technologies, such as generative AI, frontier and foundation models, and chatbots. These bills often tailor requirements to the functionality, capabilities, and use patterns of each type. And a couple examples of enacted frameworks are New York's S 6453 on frontier models, Maine's LD 1727 on chatbots, and Utah's SB 226 on generative AI. And then as for liability and accountability, that is a focus on defining, clarifying, or qualifying legal responsibility for the use and development of AI systems using existing legal tools, clarifying liability standards, and creating affirmative defenses and authorizing regulatory sandboxes. These aim to support accountability, responsible innovation, and greater legal clarity in an area that kind of has yet to be standards set for, which I'm sure we'll get into later. And a couple examples of these is Texas's HB 149 on regulatory sandboxing and Arkansas's HB 1876, which is on copyright ownership of synthetic content. There's also been a fair amount of legislation around government use and strategy, what requirements should be placed on government agencies' use of AI, and what downstream and indirect effects may that have on the private sector, on the population, et cetera. So Kentucky's SB4 addressing high-risk AI in government, and New York's A433 on automated employment decision-making in government pertain to these specific use cases. And then looking ahead into 2026, the report found that issues like definitional uncertainty will continue to arise as there's a bit of a discrepancy with different states' definitions of AI and what in particular their legislation addresses. So that will continue, I think, to come up in the next year. And newer trends around topics like agentic AI and algorithmic pricing will be addressed in legislation as well, it seems.
And we'll talk a little bit more about the importance of this later, but that definitional part is important because if you're going to, down the line, if they're going to be basing cases on a misrepresentation of what their AI tools can do, we kind of have to know what they define their AI as. But we'll talk more about that in a little bit. Do you want to talk a little bit about SB 53, the California whistleblower that includes whistleblower protections?
Yes, yeah. So at the end of September, Governor Newsom signed the Transparency and Frontier Artificial Intelligence Act, or SB 53. And it's a first in the country bill. It requires large developers to be transparent about their safety and security protocols. But that is particularly around what they call, or their definition of catastrophic risks. And that's kind of outlined as cyber attacks, infrastructure risks, and bioweapons. And it really only regulates large frontier developers. So there's a there's a threshold of who's covered company-wise by the bill. But beyond that, people in the whistleblower community have been talking about how the provisions outlined in protecting employees are not quite up to par, unfortunately. There is a very narrow definition of covered employee and the information that one can blow the whistle on based on, what is considered a catastrophic risk, or if you're working on a team that addresses these issues. So if you are a contractor, if you work on a team where this might not be your subject matter, you are not covered under SB 53, even though the information you have may still be, like, if you were to blow the whistle on it, would still be within the public interest. There's also ambiguities in the remedies available. There's a lack of compensatory and punitive damages, all of which will lead to further litigation on the types of relief available. And the caveats and qualifications required of the definitions will also contribute to expensive and prolonged litigation. And all these things that the bill lacks are very standard to include in whistleblower law. So it is it's strange to kind of see them all missing or be so limited in this context. Luckily, California already has a good public policy exception to the common law under cause of action, so that will cover a lot of AI employees. But the confusion that may arise because someone says, oh no, like, my job is not to manage like this catastrophic risk, I can't come forward with the information I have. The potential chilling effects of that is concerning. And the bill also has some pretty strange material qualifications that are not standard in whistleblower law, such as, like, one would have to prove that the information they bring forward would, the risk would cause death to 50 people or $1 billion in damage, which is not something that an employee should be expected to be able to prove just to come forward with information that they're concerned about. It's missing that good faith provision that is very typical in these types of laws.
Claire, you're out there in California. What do you think about this law?
Well, I wasn't quite so negative on it. It seemed, but you make some fair points. It seems like it was a good first step.
Totally.
There's a tremendous amount of regulation of AI out there. And in fact, in preparing for this, I couldn't believe how much there was and how confusing it all is. And they're all trying to deal with different issues. It seems like whistleblower protection is something that everybody can kind of get behind, because for all the concerns we have about AI, we definitely want people to feel comfortable reporting when there's about to be a serious problem. So it seems like a good place to start and to get people to begin to coalesce around what the protections should be. That said, I agree with you that it's narrow. There's a narrow group of employees that this applies to. On the other hand, these are people probably who are most likely to have the information about the catastrophic risk. So, it's a baby step, but it's the people we would want. As you pointed out, California already has very robust whistleblower protections for reporting violations of law. I think the trick in the AI space is that we want people to report not just violations of law. We want them to report when AI is going to harm humanity and might be something that isn't prohibited by some law, but we want people to report it anyway. And so what's interesting to me is that unlike other whistleblower laws, SB 53 and some of the other proposals that are floating around have a provision for reporting violations of law, but they also have reporting these safety concerns, which is a broader swath. That might be harder to report under receive protections for under existing law. So it is baby steps. The other thing that jumped out at me was injunctive relief is the only relief that you get apart from attorney fees for suing to enforce your rights under this if you're a covered employee. And I think the experience in the whistleblower community is rarely do people want injunctive relief. Most employers don't want the employee back, and most employees don't want to be back. Maybe that's different for these covered employees at a high level at a large AI developer. I'm not sure, but that not having damages for losing your job, if that's the type of retaliation that you suffered, it seems a little bit to be a shortcoming. But again, there are some protections under existing California law. There were some other interesting provisions in here that I liked, including that there's an internal reporting system that the developers are supposed to come up with. And, those are not always the most robust, or, they often don't work so well. But one of the interesting parts of the internal reporting that's described in this law is that the developer has to report back to the whistleblower and tell them how we have your information. Here's how the investigation is going. Here's what we found. Here's what we're going to do. And we've often said, Jackie's familiar with this, that often if whistleblowers were heard and told what was going on, that actually might take care of a problem. The problem might get addressed and the person might feel that they were heard. And the other types of whistleblower space where we bring cases to pursue fraud against the government or SEC violations, most times the whistleblower has reported and tried to get something done. And the reason they call us is because they didn't know what, nobody ever told them what happened. So they assume nothing happened. They might be right, they might be wrong. But what I really liked about this was sort of the requirement to kind of keep them in the loop.
Yeah, and that could be so helpful in so many contexts. I think to make whistleblowers feel heard is really the most important thing a lot of the time. So that's definitely a good aspect of the law. And then at the federal level, you want to talk a little bit about the AI Whistleblower Protection Act that was introduced by Senator Grassley.
The Grassley office released the AI Whistleblower Protection Act in May of this year, and it seeks to protect current and former employees and independent contractors working on the development and deployment of AI to report potential artificial intelligence security vulnerabilities or violations. The law does not require whistleblowers to prove that laws have been broken to be covered, only that they made the report in good faith, which is a great start. The as we know, law enforcement is reliant on whistleblower disclosures when industry standards are not present or held. And it's important because people are not going to come forward really otherwise. So Grassley as well kind of sees the bill and whistleblowing as one of the best ways to ensure that Congress keeps pace as the AI industry rapidly develops. In the bill, AI security vulnerability means any security breach or vulnerability that could enable the unauthorized acquisition of the technology being developed at a company by individuals or foreign entities through theft or other illicit means. And an AI violation means any breach of federal law occurring during or related to the development, deployment, or use of artificial intelligence, or any inadequate response to a concrete and specific risk that the development, deployment, or use of artificial intelligence may pose to public safety, public health, or national security. So this covers every employee at an AI company. It covers a wide range of concerns that may arise without this kind of material proof of damages to qualify. It also outlines all the remedies we mentioned kind of were lacking in SB 53, not to bash, but just to contextualize. It protects individuals' testimony in administrative and judicial proceedings, covers aiding in government investigations, contains anti-retaliation provisions that prohibit employers from discharging, demoting, any kind of blacklisting or harassing of individuals related to their protected activity. And AI whistleblowers who experience retribution would be able to submit grievances to the Department of Labor and pursue remedies through federal courts, including job restoration, which Claire talked about earlier, twice the amount of back wages owed, and compensation for damages. These protections cannot be surrendered through employment contracts or forced arbitration clauses. So there's kind of a lot of protections built into there that come from extended experience with whistleblower law from the Grassley office. There's historical precedent for doing industry-specific whistleblower protections, such as addressing the AI industry. We've seen this with nuclear energy, with government employees, with the airline industry, and with Wall Street. So everything kind of in this bill has precedent in other whistleblower law. It's standard. It's good.
Claire, did you have any other thoughts on this bill or any other of the other anti-retaliation protections for AI whistleblowers?
Yeah, no, I agree with Sophie. This is much better. Damages, it covers more. So it covers the concern about breaches of security. So that's sort of a whole other category. It doesn't have the threshold about what's harming public health. So definitely broader, definitely better in that way. I did want to mention both the federal bill and SB 53 have taken on an important aspect that they drew from other areas, and particularly the SEC, which is they prevent contracts that take away rights. And that's been a real issue in the SEC space. And so now having an explicit provision in these laws that says you can't, you have the provision, but you also can't have a contract that prevents people from benefiting from it. So that's really important in both of these. To also point out, as Sophie said, the federal law applies to independent contractors. And I do think that's a flaw in the way the California one is defined, because it does say employee. And if they, in this context, I think there are a lot of people who are not technically employees, and you don't want litigation over is an independent contractor really what was covered or not. So the Grassley bill is much more explicit. It's much more explicit also about what is retaliation. And I think it's really good. To be fair, in the California context, they use the word retaliation, but that is the word used in other California laws protecting whistleblowers. So there may be a body of law that explains what that is. But I do think the much broader definition in the Grassley, clear definition of all the things that could be retaliation is going to be helpful if it gets passed.
Yeah, it's always a big if, especially nowadays. That's a really good point about the contract language, though. I mean, the SEC is really enforcing that and going after companies for improperly putting those kinds of clauses in there. So I think that there's definitely precedent for enforcement in that area. So let's talk about how AI really, interacts with the False Claims Act. So how, Claire, can AI kind of how can the false claims in the False Claims Act be based on the use of AI?
So, False Claims Act case being based on the use of AI, that can come together in any number of ways. This is a new technology, but the theory of the False Claims Act applies to really human behavior that cuts across all kinds of technologies, old and new. So, for example, you could have a contract to provide services to the government that includes AI services, and misrepresenting that you can do what you say you're going to do is just your standard False Claims Act case. You misrepresent to the government that you're capable of providing a certain product. The thing that you provide is not the thing that you promised. You're not entitled to the money that you're getting from the government. So it's AI, it's new technology, but the basic theory is still exactly the same. The other place where we're already seeing it somewhat, and I'm sure we will see it more, is in the healthcare context, because the healthcare industry has been in the forefront of using AI. It makes a lot of sense. There's a lot of things that AI can do to help the delivery of healthcare services. They can quickly amass lots of data about diagnoses that can be useful. There's a question about how useful, but there are a lot of things that they can do to speed up the work of doctors. You can use an AI scribe to do the transcribing and things like that. It can also be used to what was the word in the first podcast? Fraud up. Anything anything a human can do, AI will be able to do faster and better in some ways, especially when it comes to amassing data. So you could, if you can upcode as a human, you can pretty quickly have an AI upcode even more stuff more quickly. And so that's going to be a kind of case that we will start to see. There are other kinds of, there the healthcare industry is using AI in a lot of positive ways. But as they were saying in the first podcast on AI, when AI is like an assistant, but it's an assistant who sometimes makes mistakes. And so you have to have humans involved. And so to the extent physicians, hospitals, other providers are turning over their obligations to make individual medical necessity decisions, make diagnoses appropriately. To the extent they're turning that over to AI and not involving human decision making, it's going to produce false claims because people will be claiming money for things that were not needed, weren't done, etc.
I know that the government is also using AI to root out fraud. I think CMS has a pretty intense algorithm that they're using to try to find outliers and things like that. How is the government kind of using AI to help them root out fraud?
Well, from what's reported, there's a number of experiments that they're doing. So CMS has a couple. They have interesting acronyms. One of them is called
Yeah.
WISER, which they're rolling out, and they're going. I think they've issued a request for proposals for companies to come up with an AI model to focus on diagnoses for certain types of conditions that are prone to fraud, and there are three of them. I think were skin and tissue substitutes, electrical nerve stimulator implants, and knee arthroscopy. And so they want an AI to go and search, have a model for searching for that, so that they can determine, are there sort of hospitals or providers who are outliers, and that they can then use that to investigate. So that's one way where they're kind of trying it out in particular areas, hopefully to see where it works. I thought it was interesting that the companies that they plan to contract with will get a percentage of the recoveries, kind of like whistleblowers.
Mm.
We'll see how that works. But that's one experiment. Another experiment I was just reading about is the crushing chili cook-off or competition, where they have a competition going to have companies present their plans for AI models that can detect fraud. And they're going to pick a couple of participants who will then make it to round two, and then they'll have
Yeah.
some winners. I wasn't sure. It sounds a little like a television show, but it may work. They're trying to get the market to produce the best models to detect fraud. So it's creative, innovative. Um, the earlier this year, there was a takedown notice about a whole group of defendants who were charged with fraud in various contexts. And the government recovered 14.6 billion in alleged fraud, or that was that was the charge anyway. They hope to collect that, but there is discussion of how they use data analytics to detect a lot of that fraud. So you can see that they're kind of pulling those kinds of resources. Um, and then the working group between HHS and DOJ has been very clear that that's one of the things that they're focused on. So I think there are a lot of experiments going on with using it to detect fraud.
Yeah. New and exciting times. Um, Anything else, any other ways that AI is really impacting the False Claims Act practice that you've seen?
Well, the only other thing I might mention is that, you know, AI will also help whistleblower cases. Though we've already seen some cases based on data analytics. So whistleblowers
Mhm.
coming forward with statistics that they did, much like what the government is doing, where they've looked at large bodies of data and found outliers, and then brought False Claims Act cases based on that. Some have been successful, some not, based on the quality of the data and what else the whistleblower is bringing to the table. But I think that kind of effort can enhance the cases brought by whistleblowers. Statistics can help play out theories that the whistleblowers have. Um, and maybe some cases based on really good statistical models that alone will be enough. But that's kind of another area of debate that we'll be
Mhm.
seeing.
Yeah, definitely. Well, any last words, Sophie, on kind of where we are with regulations and anti-retaliation?
There are ample opportunities to protect people who need to know what their rights are, and having a federal bill that outlines a clear path forward to reporting to what counts as covered and who's covered will be extremely impactful for people's belief in their ability to go forward. So even though there's already existing whistleblower regulations that may cover what people are seeing, without that clear path to reporting, people just have no idea that they are covered. And so it would be a signal to so many workers, in the AI industry and beyond, that what they're working with, that they're covered, that they can come forward with potential violations as long as they believe that wrongdoing is happening.
Yeah, no, that's such a good point, though. There may be other protections out there. There probably are, but unless you're calling out AI specifically, you just don't maybe think that you're covered. You don't realize that you're covered. And so this is these regulations can be a really good step forward.
Something we hear a lot, I think people cite back to the fact that because there's no overarching regulation of AI at the federal level, they say, well, that's illegal. And so it takes kind of, in that absence, you need to outline that with a whistleblower bill, because we don't really have another way to get that information right now. And people don't
Yeah,
believe that they're covered until that is made clear.
yeah, absolutely.
No, I agree with that. And that reminds me of another thing I wanted to point out about the California law, which I think could be in addition to the federal law. And we have it in other federal laws, which is California has a notice provision. Now, you've persuaded me that the notice provision isn't very good because you're only talking to a couple people about it. But it's a really important point that having a notice provision to employees, as the California law does, which is to tell them that the employer is required to tell them what their rights are, is really important. And that's also been a provision in the Defend Trade Secrets Immunity Act, where not only do you have this immunity, but employers are required in contracts and policy documents to provide that notice to employees. And I think that might be a good addition to the federal law as well, because I agree with you. If people don't know that they can report, it's going to deter them from reporting.
Well, thank you both so much for joining me. This is really great. And thank you all for joining us on Fraud in America. Thank you to Getnick Law for sponsoring our podcast, and we'll see you next time.
Thanks, Jackie.
Thank you, Jackie.
Our annual sponsor is Getnick Law,
a boutique Manhattan law firm dedicated to fighting fraud and promoting business integrity. Learn more about the firm at www.getnicklaw.com. If you believe you've witnessed fraud against the government or on the financial markets, or want to learn more about the laws that exist to fight fraud, visit taf.org, where you can find a directory of whistleblower attorneys who work across the country. On our website, you can find information about the nation's whistleblower laws and programs, and a way to donate to our organization as we continue to fight attacks on whistleblowers and these laws. Fraud in America is presented by the Anti-Fraud Coalition. Jacqueline DeMar is our host. The website for Fraud in America was designed by Wide Eye Creative. Our artwork is by PPA Agency, and our theme song is by Spatial Relations.